So hi Girija. Now
Nice.
it seems like very scripted when I say hi because we just spoken to each other. So that's a strange thing. But thank you very much for being part of the symposium. And I'm looking forward to your Indian perspective and your vast experience. So please introduce yourself. And it's your presentation from now. I'll come in only when you tell me to come in at the end or whenever you want me to come in. Okay.
So thank you very much, Vikram. And I must compliment you for the great project that you've undertaken and got us all together. It's amazing, the hard work and your enthusiasm, and to hear perspectives from around the world. I think it's a very useful assignment that you're doing for all of us. So I'll go on to introduce myself. I'm a dispute resolution professional with expertise in intellectual property and commercial laws. I handle cross-border transactions and agreements, IP portfolios, which is intellectual property portfolios and licenses, investor relations, commercial, corporate, and civil matters, and anti-corruption law issues. I also work on recovery of damages and compensation for my clients. Often I'm appointed as an arbitrator and a mediator. I have been a sole arbitrator and I've written several awards. And I'm also an associate CR certified arbitrator. As a mediator, I have successfully mediated about 70 plus international and domestic disputes. I've been trained as a mediator from Stanford Law School, then the Delhi High Court, and also the Singapore International Mediation Institute. I'm a mediator on the INTA board, committee, which is the International Network of Trademark Attorneys, and also with the Delhi High Court and many international panels. I've been a fellow with Stanford Law School. I have a master's from Cornell Law School, and I'm also a British Council Achievement Scholar. I've also worked in diverse industries. I worked as in-house counsel with Microsoft, with HCL Hewlett-Packard and Standard Chartered Bank, and also with some top law firms like Amachan, Mangaldas, and Herbert Smith, that is in London. And now I am doing a lot of arbitrations, and I look forward to doing more mediations as a mediator. As Vikram said, today's presentation is going to be more about mediation in the Indian culture, because mediation holds a very special place in the Indian setup. It has been there traditionally and also not been there traditionally. So in my talk today, I'm going to explain the nuances of the Indian culture and mediation. Now, as a society, Indians are a very gregarious society. They are hospitable people. They have strong kingships, and they're friendly people, mostly unreserved, and we have very informal relationships. So, unlike so much, say, amongst Americans or the Britishers, we just walk into a friend's house and spend hours together chatting, catching up. Well, slowly things are changing, and people do, because of distances, people do make calls and, then drop in. But as such, it's a very informal kind of relationship, and we are quite intertwined with our friendships and relationships amongst ourselves. And we have, very close-knit relationships. My friends would be an aunt to my child or an uncle to my, relationship. So we call, call people with names which gives them the feeling of being more a part of the family and a more close-knit, culture as such. Some of the things that are interesting is that we form very strong connections with other human beings. At a very different level, we try to be spiritual, sometimes we try to find commonalities. So there is a very strong sense of, connection with other human beings. We do have, or we can say we do suffer and also enjoy a lot of traditions. There are, many traditions going on for many, many innumerable years, and we kind of live within them. They become a part of us. Some of us do find them difficult to break away, but they also exist there. So somewhere that is a background which always dictates any form of conflict or dispute resolution for us. And as such, we could say that the Indians hold a relational worldview as such. Now, one of the strong things that we see in India is the diversity. Now, diversity can be positive, and diversity can be also very negative. Why do we say diversity? Because which comes from many, many, many factors. Some of which are, one is diversity comes from disparity. Now, disparity is, we could broadly classify Indians in 4 sectors broadly, which is the low income group. Then there is the middle class group. And then there's the upper middle class, which is the highly educated group of people. And then there are the business class and industrialists, which is very high income groups. So, there is a lot of disparity and differences in cultures amongst all of these, because the way they do business, the way they conduct themselves within families is different from each of these sectors. Then the other form of diversity that happens is there's a huge difference in cultures. There's so many states in India, almost 28 states in India, which have different cultures, different cuisines, different dialect, different way of operating. Some of the states, it is a matriarchal society. Down south, also somewhere in the northeastern side, there are some relationships which are matriarchal society. Most of India has patriarchal society, but that makes a lot of difference because the head of the family is different. And then also that there is diversity because how are women treated, how are men treated in these societies, in these states is different from what they may be done in most part of India. So there is diversity there again. But here again, it has an impact on mediation. You must be wondering why I'm saying all this, but this culture does definitely have an impact on mediation, on the way businesses are done and how families are set up. Now, there's also a divide between the north and south part of India. There's a huge difference in culture there, and I'm sure Vikram can relate to it and see how, culturally, how business is done differently between these two sides. And we have almost, we have Gujaratis, we have South Indians, we have Himachalis from different states who have different cultures. Now, this diversity also brings in different kind of conflicts. And also, there's a difference in problem solving of these conflicts. So maybe a mediator has to bear this in mind, because when you come from a matriarchal society, the elder in the family is different, and how they operate, how the woman's role is in that family would be different from what it would be for a patriarchal society or a patriarchal family. So that's how diversity, I think, has its own set of issues that come up, but also it brings in a lot of creativity while we are doing problem solving. Now, I'll just give you a few examples where, there are problems and issues and conflicts that we see over the last few years in India. Firstly, I will broadly categorize it into 2 forms. One is the business side and the other is the family setup, because these have a strong bearing on the Indian culture. They have a strong bearing on the society and how we are going to resolve disputes for our society. Now, businesses in India traditionally grew from homegrown businesses. So brothers and sisters, and mainly the brothers and the father of the family, would set up a business and run it. And that's how businesses were done. And also there are mom and pop shops around. So they're smaller setups, but they grew into bigger businesses. So what really happens in such issues, such kind of setups, is that these are informal setups. They don't have very good accounting systems or a very strong accountability of what is happening within the business. So these businesses, the issues that we see that are arising are ownership issues. Now, which can be very difficult to be decided through a court sometimes, because there can't be a procedure or law on, now there are two brothers and there's a father and there's a business running. Now who's going to have the ownership of the business is going to be issues. So that is one part of issues that we face, and we are still not broken away from that. If you see, traditionally, the law firms are all home family run businesses. So the partners would be automatically, the family partners, they are the brothers or the sisters. So a third party would rarely be taken on as a partner, but now things are moving. Now we see that there are going to be much larger law firms with more partners being inducted inside. But the control continues to be with the family. And there are many ownership issues that arise in such setups. One of the examples that I can give you is in intellectual property. Now, there's a situation, say there are, a father and two sons running a business by the name of, say, Reliance Industries. Well-known name, well-known brand. Now, there are issues that come up as to who's going to own the brand Reliance. It's very difficult for a court to decide this because they all have been a part of the business. So here, I think mediation plays a very, very important role, because they can carve out solutions in such situations. It will be very difficult for a court to decide on such issues. And so that's where we see that mediation is also picking up, and that's where it's got an important role to play. Then there's also a lot of entrepreneurship that is happening amongst the low income, the middle income, and also the middle educated class of people who are doing there's a fair amount of entrepreneurship going on, and Make in India is a big buzzword now. So what we see is that traditionally businesses were not a very well organized sector. People would just go ahead and do businesses. They were not accounting systems were not put into place. Till date, I have people who if somebody's doing, say, a woodwork job or a contractor's job in the house, they just give me an estimate on a slip of paper. It's not on a formal documented invoice. That's a very common practice in India for many businesses. So this kind of issues also arise where it's very hard for a court to decide again, because they do not have proper accounting systems. A large part of India depends on that. A large part is, the metro cities are the, main cities, which are like Delhi, Bombay, Calcutta, Bangalore, Hyderabad. These are metro cities which still maintain good business standards and governance. But what about the second tier cities, which is almost 3/4 of India? They don't maintain such strong accounting systems. So in such situations, it's very hard for a court to decide if there is a issue that arises as to who is entitled to what, who is entitled to what money, who's entitled, or if there is a breach of any form of understanding between the parties, because there are hardly any agreements that are signed up. So we see these issues, and I feel again that sometimes the court would find it a challenge to handle these issues. These are, of course, these are traditions which are changing now. They are bringing in more. They have brought in GST, by which they are monitoring a lot of transactions that are happening, but it'll be still a far, cry till we are able to actually make the entire business sector of India more organized and more accountable. So there also, most of these issues, we also see that the elders in the family, the elders in the business, the head of the business, very often steps in and helps to resolve the issues. That's how it has been worked traditionally. And some places we continue to see that, because the elder plays a very important role in the Indian culture. And I'll explain that a little bit further. But I would like to quickly give you another example, which is very, very important in business also in India. If we look at it traditionally, sale of property, there is always a component which is the accounted for component, which is by checks, there are payments which are done like that, and the agreements that are signed up. But in a property dealing, very often, almost in 80% of the transactions, there's also unaccounted payments that are made. Now, that money has, when it comes to mediation, it can be spoken about because mediation is a very confidential process, but it can never be done through the court process. And, we couldn't buy property without doing this in India. It's almost like that because all the setup is made in such a way where there is always an unaccounted for money, which is even with the topmost builder. So today, there are cases which are going on where the builder has not, who's breached the contract and not given the finished building, or the houses or the offices have not been, the units haven't been completed. Now, the consumers, the users are fighting for their money. But what do? They can't fight for the money which was given unaccounted for. So I think in such situations, mediation is a very good form of dispute resolution. And I think that is growing, and I hope it will continue to grow. Now, I do need to flag off one of the main things is the elder syndrome, which is that exists in the Indian culture. We see this as because the elder of the family, which is in a family setup or a business setup, the elder is the head of the family, or in a business, it's the person who is the promoter of the business or who set up the business, plays a very positive role very often in mediation or in resolving any problems. Now, it's a very informal setup, but what are the sanctions? How do they ensure that this is done? It is done mainly by, there could be, if somebody doesn't comply to what the elders suggest or state, it could be that they would be dismembered from that family or the society. So that is the fear or the sanction of doing that. I think most of the industrialists and the high income group, of course, resort to the legal system because they can afford it and they can, they have far more organized sectors, so they can manage to go through the legal system. But ultimately, I think even there, because of the delays in the court, because it takes very long for a trial to come up and there are lengthy trials, there's also discovery by which a lot of the business dealings have to be revealed and it has to be out in the open. I think for that reason, mediation becomes a good option for a lot of people, even in that sector. Now, I do feel that the elder syndrome needs to be discussed again in the family disputes as well. Because now we also, as I said, the family setup is also undergoing a change in India. Traditionally, we were joint families. We would be, after even getting married, the son or the daughter, the son continues to stay with the family, with his wife and his children. So the grandchildren and the grandparents are all together, which is very unique to the Indian setup. It is also there, I think, to some extent in Japan and to some extent in other countries as well. But mainly, it's a very important thing traditionally from the Indian perspective. So here, the elder of the family, which is the father of the family, or sometimes the mother of the family, holds a lot of respect and holds a very different position. So whenever there's a dispute, maybe between a couple, between their son and daughter-in-law, the father and the mother may step in sometimes to help them resolve the dispute. But it also has now, we see in the last few years, 10, 15, 20 years, that this is creating a lot of conflict within families because now the younger generation is moving more towards being individualistic. And they're breaking away from the joint family. They want to look at themselves as the key person and be more independent and be more on themselves. So we see a lot of family couples that are getting into divorces. There are families that are having issues in distribution of inheritances and their assets. So I think the role of the elder is slowly diminishing. But it still holds a very important factor. And as a mediator, very often when any kind of dispute comes in, whether it's a business dispute or a dispute which is a family dispute, at the back of my mind, as aware of these cultures, it's easy for me to steer through these issues and try to understand where some of the elders or some of the senior members in the organization are coming from, because they come from a different culture. Today's culture amongst the youngsters is very different. So the conflicts become very, very different. And it's the internal conflict for the individual and the interpersonal conflict with the family and the community. There is a vast disconnect there. Now, how far do we think that the legal system can intervene in a family dispute or a family-run business dispute? I think, as I said, mediation is a very good answer there. I would really like to now speak to you about the elder syndrome, where the elder of the family or the business makes the decision and calls all the shots. Simply the other family members and the business holders just kind of accept it and they go along with the elder. And that's how businesses have been successful in the past. So in mediation, it is very, very important to understand the role of the elder is very, very important. What we've seen is that even eye-to-eye contact with the elder is sometimes considered to be disrespectful and challenging behavior. It's like challenging the authority of the parent or the aunt or the uncle or the grandparent or the elder or the business head within the organization. And these are sometimes considered to be a taboo. Therefore, it is for a mediator, it is therefore very, very important to create a space for more meaningful, productive, and difficult conversations that happen between the elders and the new generation in the that is, even irrespective whether it's business or family. Now, we've traditionally had the panchayat system, where there is a panch or there is an elder in the family or the community, or known as the tribal head, who actually would step in and resolve disputes in the past. This is before the British era came in and before the legal system was formalized in India, and it became a much more adversarial form of resolving disputes. Now, what are the tribal governments, as we call them, or the panchayats that we call them? They're informal mediators, but actually they're also the decision makers. Because they look basically at what? They look to the needs of the individual with the needs of the community. So they're trying to balance that because they want the individuals to continue to be a part of the community. The sanctions that are attached, as I said, to such kind of setups is that if the individual does not follow what the tribal head is saying or the panchayat is saying, they could be ostracized. They could be dismembered from the association. So that is more stringent sometimes than what the legal system might impose on them. So the decisions are based both on tradition and the current time practices. So what is lacking in the system? We do say it's mediation, a form of mediation, but one of the key factors which is lacking in this form of dispute resolution, which is the panchayat system, is that there is lack of communication between the parties, which is the mediator's role. They're supposed to be getting the parties to communicate with each other. But here it doesn't seem like that, because it is the elder who decides. They are not getting the parties to communicate with each other. They may hear the viewpoint of the two parties, but the ultimate decision lies with the senior member. And the other parties the disputing parties have to only follow them blindly. They cannot challenge that authority. That's how it has been traditionally. There's a lot of tribal pressure on the individual to consider the relational needs of the community as greater than his own needs. So there is no place for your own needs very often. But we now see the conflict, as I said, with individualism coming in, that people are moving away from this and they want, different forms of dispute resolution. And so we come to different forms of mediations and different forms of techniques that we use in the mediation process. So broadly, I would say that we use different forms of mediation, and some of these mediation processes that we use are, as you would know, is the facilitative mediation, where the mediator is a professional mediator and he attempts to facilitate the negotiation between the parties in conflict rather than making recommendations or imposing a decision. The mediator encourages the disputing parties to reach their own voluntary solution by exploring each other's deeper interests. In facilitative mediation, mediators tend to keep their own views regarding the conflict as hidden. So we are using facilitative mediation sometimes, depending on the situation. We would use this more often. This would be in family setups where you would just allow the parties to find their own solution, because, as I said, in family setups, it's very difficult for anybody to intervene and be able to give an opinion or to, help them or give a solution to their conflict. They can help them communicate. And then is the form where there is evaluative mediation. It's a type of mediation in which mediators are more likely to make recommendations and suggestions and to express opinions. Instead of focusing primarily on the underlying interests of the parties involved, evaluative mediators may be more likely to help parties assess the legal merits of their arguments and make fair determinations. We see this form of mediation more in intellectual property disputes. They may be able to see, okay, so-and-so has, come up with this innovation or a particular form of product which is new, and how they can work with the other party in a business setting, or may be able to work out a solution by paying license fees or giving up some money and work out relationships there. So there the opinion of the mediator can help, because the mediator can find solutions for the parties, which the disputing parties may not be able to see themselves. Then there is the transformative form of mediation, which we feel is very, very important in the Indian setup. In the transformative mediation, mediators focus on empowering the disputing parties to resolve the conflict and encourage them to recognize each other's needs and interests. The process aims to transform the parties in the relationship through the process of acquiring the skills they need to make constructive change. So here there is a transformation in the parties' stand. They are able to see the interest of the other party as well as their own interests and bring about a change. This form of mediation is also very important. This helps both in businesses as well as in family setups, because if there is a change, then there is hope for the conflict being resolved. Some of the successful forms of mediation also have been the court-mediated settlements, because, as I said, the elders play a very important role. I think here the judge steps in as the elder, and when they are disputing parties in court, then they would be more open to listening to the judge and probably looking at options to resolve the dispute. This is used very, very minimal in the court system, but it could help in a lot of these where there are traditional issues coming up to resolve disputes. So broadly, this is what I would state is happening. We also have the Lok Adalat system in India, which is one other form of dispute resolution, but that is done in a mass scale. For example, there is an Indian huge public sector unit, for example, the housing sector, which is the DDA sector, the Delhi Development Authority sector. Now they have innumerable disputes going on with the housing for their housing units with the consumers. So they may have a lok adalat, which would be set up on a particular date or a particular 2-3 days, and all and every who have disputes with that particular PSU may come in and get their disputes resolved. It's not a form of mediation, it's not a court system, but it's somewhere in between, which helps the parties to quicken the process of litigation that has been going on for many, many years. So they would quickly resolve that. So that's how even those have been very successful in the Indian setup. So that's exactly what I had to say now, Vikram. So I close my presentation here. Is there something else? I'll be happy to answer any questions or discussions further.
Oh, thank you very much. And with your experience, definitely some interesting things come up. And I'm telling you, this is something which is coming up from a lot of countries. I would say most countries, this aspect of the individualistic society that has developed or is developing has been a major factor in moving away from traditional dispute resolution. So these are, I think, signs where countries can pick that sign up fast, or people can pick that sign up and start moving towards going back to what was happening. And David is here. He gave an excellent presentation yesterday about how he is looking at this is really a model which is according to me perfect. He's saying that you have the traditional system and what we call the modern system of mediation. And in double quotes, modern. So he's saying, why not we have a hybrid system? Take the person who has that, who's doing the traditional method already. In his case, he was talking about these Jews who came from the Balkans into Israel, and how the rabbi was a very important person to go to. Now, if you can have the rabbi on one end and you can have the so-called modern mediator, and you can have co-mediation happening. So you bring in the advantages of one, the power imbalance aspect of it, or even the fact of one person not being able to speak out in the traditional system. So that by itself is a major issue in most traditional systems. And yesterday we also had Virash from South Africa, and she was speaking about the fact that these women from villages, they do not get a voice in that mediation. So when that mediation happens in front of her, she gives them a voice. Those people can talk. And I was asking her, which is interesting, that I said, okay, successful or not successful, when they go back, does it change the system in their families? And she said, he gave an actual example where that happens. Now this husband has heard her. First time he's really heard her. He goes back and tells his family, look, this is what she thinks, because she was started working, and obviously the structure changes. So I mean, very interesting things are coming up from all this, and this is a common thread which we have to realize and be able to take forward. How we take forward, I told you, David's method, I feel, is really something which can be adopted very fast. This is something we have the mediators all out there, and so many of them, they don't have work. Andrew was there yesterday. In the UK, he's saying there are 18,000 mediators, 500 have work. So first of all, how do they work? How do they get their work? So that is one by itself a thing. So what do you think in India as a person? I keep saying, private mediation, we never should qualify mediation as private. Mediation has to be private. The court is an anomaly, and that should not happen. Well, that's a different discussion we'll have. But in terms of private mediation as such, what is the situation? Can a person work as only a mediator? And what are the challenges there? And the law?
Hi, David. Nice to meet you.
David, you can say hi to her. One of those rare opportunities to get you unmuted during the session.
Yeah, so I must say that I'm totally in sync with you about the hybrid system, because I've co-mediated a matter also, and I see that there is a huge potential. There's so much more that you can do as a co-mediator with somebody, because they definitely two heads are better than one, for sure. And then as you rightly, as Vikram put, that you must have suggested, I'm sorry I missed your presentation yesterday, but I would say that yes, understanding the cultures from one person and understanding it from outside the culture makes a lot of difference to finding a solution, I think. So that's a very, very important and key point that is made. I don't know how it is outside of India, but in India, we have not encouraged much of co-mediation. But internationally, I know co-mediation has a very, very important role. I don't know how it is in your country or in other countries. What do you have to say?
I always co-mediate.
Okay.
Always. All of my mediations I do with a partner. Um, she's a lawyer. I am not a lawyer, so we already have combined abilities.
Uh-huh.
And I run quite a big school of mediation in Israel, and all our training is towards co-mediation. I find that teaching people to co-mediate will make it clear that they have no authority in the room because they have to share. He's not the boss of the room, the mediator. And once he has to share the running of the session with the co-mediator, I think in a way they show some kind of humility, some kind of no one here is in charge, no one here is the boss. It is very challenging to learn how to co-mediate because most of us are accustomed to do things on our own,
Yes.
especially when I train judges or senior lawyers or people who retired from the military or even school teachers who I used to do everything on their own to run the show, and suddenly they have to share the work with somebody with the same level of authority. So I'm very much one objection to co-mediation is, of course, you have to share the income. The customer pays the same fee, and you have to share it. But I out of ideology, I co-mediate, and we share the fees. We take good fees, so we can share them. And yeah, I'm
We
in
need
favor
you
of
in
co-mediation.
India now, David.
Once the COVID is over, I'll be glad to come.
No, David, no, David. The world needs you. Please stay online. The world needs what you're saying. They need your message has to go out. So the co-mediations that you do will be a very limited aspect. How many can you do? But the message that you have has to be taken all over the world. If we can actually have that hybrid of the traditional mediator and the modern, again, double quote modern, modern mediator, and we can actually help set up a system for those co-mediations. There will be work there. There will be work there to explain to that traditional mediator that, look, this works for you and those people who will be able to then keep that respect for you. Otherwise, you will lose whatever existence that you have over time because of this individualistic society. They will move away from maybe you itself, be it tribal chiefs, be it rabbis, be it anyone. People are moving away. So this, I think, is a very good thing at this stage. And certain countries like ours, where the rural population is so large, or 60% if it's rural, and today we haven't got that problem as much as other countries have. We have only 18 million. I'm saying only 18 million cases going into courts. Only the US has 100 million cases. So has urbanization gone against them so much? What are the issues there? I mean, community mediation centers they've opened, only 400. Only 400,000 cases in the 40 years they keep talking about mediation. So this is a good time in a lot of countries to pick it up. Like yesterday you were there. I don't know, you might be not there when the person from these people from Vietnam were there. They've set up a very good system in terms of, okay, it's only for the land disputes, but they've gone down to the village level and actually created a system there where they've used that traditional concept. So good things are happening. But look, the conversation will happen and lots of conversation will happen. But Girija, today this is your session. So I don't know, David, if you don't mind, I'll just put you on mute. And Girija has to answer that part of what is about private mediation in India, challenges, law, and what do you see there?
So, well, we in India have, I think, one of the oldest laws in mediation because the Arbitration and Mediation Act of 1996 has the appointment of a conciliator. Now, the definition of conciliator is slightly different from a mediator, but it does not mean that it doesn't cover a mediator. It does. The conciliator's role is more of an expert, and he comes in and does a very similar role to a mediator, only his expertise has its own place there. So I think the Indian law does recognize that, and they have set out the definition of that. They have set out how the process works and what the outcome is. Where does the outcome stand in the Indian system? It's very, very clearly spelled out. So it's not that it doesn't exist here. So we can say very confidently that traditionally mediation systems existed. However, they were, through the panchayat system or the elders of the family system or the tribal head system. It existed. Then the law came in, which is the earliest was in 1996, the Arbitration and Conciliation Act. And then we also have it now, say in the last about 15 years, also in the Civil Procedure Code, where the court is very often has a mandate to send the matter for mediation. And they need not be in agreement between the parties. So the courts are taking a very, very active, proactive role in this. They're trying to send as many matters for mediation as possible. But I still think that there's always a flexion point for mediation. It cannot be at any stage of either litigation or pre-litigation. That's a judgment which needs to be taken. When are the parties ready for that mediation? It doesn't happen always, because very often we see parties don't even come to the negotiation table because they don't see value. So that becomes it becomes like an unsuccessful process. Whereas they see the value later, maybe at another stage where they are. So that's one part of it. And I think as so far, there is very little private mediation that is happening. It's mainly through the court processes that mediation, because the mediation centers are all attached to the court, whether it is down south or whether this is in Delhi or Bombay, wherever, mediation centers are attached to the court. I think we need to break away from that and start seeing mediation as a private run business, which lawyers can adopt, which non-lawyers can have, which businesses can have. But it should be, because ultimately it is the skill of the mediator which matters. It is the skill and what form of process he uses or she uses to mediate a matter, or to bring the conflicting parties to the table and to get them to resolve their disputes. And yes, some amount of legal knowledge definitely helps, because the final settlement agreement, the terms need to be set out in a way so that they stand muster. So it is important. You cannot say that the lawyer has to be excluded. We have to be there. I think all three of at least Vikram and I are both lawyers. So I think we still see a role of ours, even as private mediators also. Very important role. So I think, and also, the way the legal system is set up, an understanding of that is very important, within which the mediation happens. Because if my legal expenses are going to be so high, or my outcome is going to be so uncertain, I'm more heading towards mediation there. Then I see that as a very important way of resolving the dispute. So yes, private mediators is very, very important in India, I think. And I don't think a legislation should be there which is very strong. It should be just very simple legislation, because this is a very informal process. You will take away the creativity if you try to put it too much under the legislation. You will take away the ability to mediate anywhere, anytime, any dispute, if you put it too much into a legislation. So that's my view. But of course, there are many people who feel it's very important to have a legislation. I think more important than that is that the mediator should be paid well. That is what they should have there. So that's going to give everybody an impetus towards mediation.
And that is, Girija, my view also. And if you hear my passion for it, I would say, the way I talk about it, even with Andrew yesterday, at the end was just about this, but the fact where the court system has come in and what it has done to the private mediation and how it will finish it off. Because there was one senior mediator from India, he was in a webinar, he was talking about his experience. He said, I set up a mediation center with some lawyers and was doing really well. And suddenly the court sets up a mediation center in the court, obviously if you give it for free, almost, they had to shut it down. So now imagine from private mediation, if you have to shut that off, where are we moving towards? I mean, are we going to be able to develop a profession? And we have to ask ourselves that, are there vested interests? Is there self-interest which is going to affect this profession developing? Because I keep saying, I mean, you're part of the court system, so I mean, like it or not, but the fact is that today in the mediation centers in the court, you're in the Delhi High Court, definitely you get people, mediators, they get a little higher than what is happening in other parts of the country. But say in Madras High Court, it is $100 for the entire mediation.
We are the poorer cousin. It's still considered as the poorer cousin of the dispute resolution.
All I'm saying, and it could be 25 sessions. I don't know how many sessions are going to be. And all I'm saying is that in those courts, you really want mediation because you want to clear the backlog. I'm saying at the same time, set up something called a litigation center. A lawyer who wants to litigate in the court gets registered there and is paid exactly what the mediator is paid. The lawyers will be out on the road with this, even if that conversation starts. Just the conversation, forget it be implemented. Us mediators have to rise above it all. We are doing this noble job. The lawyers are not. We are doing the noble job. We have to be paid $100 for the entire session. Tell one lawyer, for the entire case, you will be paid $100. What is going to happen to that profession? First of all, will they ever let that happen? So I think maybe that voice of mediators has got lost, because we are decent people. We are nice people. We are wonderful people. Whatever words, I can keep talking about it, because I meet so many people from all over the world. I can see that commonality between the people, as traits, as everything. And these are people I'm saying with the mediator mindset. You spoke about the lawyer thing. I am not into that whole concept that lawyers are required. I'm saying lawyers have expertise. Any expert, get the expert in. Legal expert, get the expert in. So in a construction dispute, you need an architect, you need a civil engineer, get them in. But also at the same time, let the civil engineers be mediators. So let lawyers also be mediators. It's not saying that you don't have lawyers as mediators, but it's not something that has to be part of the essential aspect of the mediation in the world, because that's taking away from the whole process, because the process is not about the positions of the party. The whole concept is to be able to get them out of that. So I think maybe the whole way it's structured, because look, the US model is pushed all over the world. In the US, the lawyers have taken full control of mediation. If those 100 million cases are filed there and 90% don't go for trial, is because the lawyers are getting the full chunk of the money that is generated from that. The court system, the lawyer there, the mediator there gets $40 an hour. For otherwise, the lawyer would be charged, the mediator would charge some $200 an hour, maybe more, I mean 500, whoever. So he's doing it in that hope that some lawyer will recognize him or her, or whatever gender, recognize them and then take it forward. They don't do that. I mean, there was one particular mediator, senior mediator from the US. He's just spoken about this aspect, criticized the entire court system and the way it's happening and what it's doing to the profession. The young people come out. They're thinking, yes, in the court system, we'll get recognized. They get disheartened because nothing happens after that. They move on. It's a very, 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 very complex way that mediation is developing in some parts of the world, which is picked up by various countries. Thinking US model, not going into where the problems in the US model is. If in 45 years, a mediator cannot work only as a mediator, matters don't come straight to a mediator, but go to a lawyer, there is some fundamental issue the way it is practiced. Is it because we have the wrong mediators? That means the whole training and certification process doesn't work. The same thing Andrew spoke about the UK. We call them mature markets. He's still speaking about how certification has gone wrong for them. So it's just, I think, we are picking up what you just said, that this new law and everything, some people want to regulate. You said exactly what I keep saying. Please, it's a non-formal process, and I'm stopping you from speaking. You are going to speak. Please, yes, Girija. Yeah, I stopped you a number of times, but
no, but I think that one of the key things that we're, finding is an issue is that, there are people who are straight out of college who become mediators. And I think that is not really very fair, either on the mediator or on the training process, because mediation the skill is developed only through experience, and it has to be taken into consideration, because We have mediators who have 2 years experience. Neither do they know the law, nor do they understand, uh, human behavior or the business setups. It's very hard for them to help a mediation. So the mediation skill is so important, and that only comes with practice. It only comes with experience. That is my understanding of the thing.
I tell you,
Because
again, this is something you've taken me into an area where, of course, I am going to be telling you, which I've been repeating, is that there's something called a natural ability. If in the village
yeah,
system there are only some elders also who are looked at to help them resolve the dispute, is because the community understands and trusts only them. It is not a matter of all elders. It is very clear. And I'm talking about even the school system. I'm saying in the schools there are students who people go to. It's not everyone can be a mediator, and everyone is not a mediator. So we
yeah,
have
that's
not
true.
been able to identify those people with the natural ability. We have not valued them. I'm saying we haven't valued them. They are the ones who are doing what is required in terms of dispute resolution. And I was telling you about the rural population in India. We have to go back. I am sending people to villages. I am telling them create that database, because we don't want to lose these people. With the urbanization and the individualistic aspect, these people will get lost because they don't value themselves. It's a natural ability of theirs. They don't even understand. They've suddenly helped them resolve a dispute sitting there. And how did they do it? They don't know theory. You can't go to ask them what the points, what is vatna batna and zopa and all. They're not getting into all that. They are just there to resolve the dispute, and they do it very well. They're trusted. Imagine, these are people who are trusted. They are qualified to do it. Who is qualified to be a mediator? Who's trusted by the parties, who helps parties resolve the dispute, has a whole history of doing it. So we have to get these people into the fold, get them into making it a profession, which is what I'm trying. I'm saying I'm trying it on, let's say, a model system. Let's see how it works out and what are the issues come up, and then we'll take it to all parts of the world. And I'm telling people from other parts of the world, please try and do this. Send out a form if you have to. Talk to people, because we have to do it at scale. And if these laws come into the picture, which obviously there are vested interests and there is self-interest to bring this regulation out and regulating. Because let me tell you, I was also speaking about it, and we have some time, because Sarah, just who's the next session, she just sent me a message that she's getting has some connectivity issues, so she may take 10 minutes more to connect. So we have time, so not a worry, you'll get to say what you're saying. But I'm just saying that in terms of the self-interest, I told you the courts, backlog. Why is there a backlog? You understand that if you have 500 judges and they can't do the job, make 50,000 judges. But that one person who is sitting in that jail thinking he's innocent, justice will be done, and the court is sitting there counseling parties on a divorce. No, you should go for mediation and all that. That 2 minutes also, if he takes time of the court, and that person who's sitting in the jail doesn't get out and he's innocent, there is some fundamental issue that we have created. And this court system as such, this whole colonization in the court system is a problem we're looking at from all over the world. So that part of it has to be discussed. And I mean, at the end of the last day, we'll get into that aspect, how that has worked for the world. And the other aspect is that the institutions and their vested interest in training, because I told you what has happened in the UK, what Andrew spoke about yesterday. You churned out 18,000 mediators and you have only 500 who will get work. So there is a major issue in the churning out process. So why are you churning out people instead of the people who already are doing it? They have the natural ability and take them forward. So those are, I think, a lot of issues that we will take up, and we will keep taking them up. Because if you talk about the mandatory mediation aspect that is developing in a lot of parts of the world, Giovanni is here, the Italian model is being picked up by people. I keep saying that, one, why did that have to happen for the courts? Why did they have to do it? Because they had the backlog. Why did they have the backlog? Because they could not do their job. Now someone is not able to do their job, is telling people to do something which is diametrically opposite of what they do. Litigation and mediation are two different, the north and south pole. And if the judge has to tell people, or the court system has to tell people and force them that you have to go for mediation, then that means there is some fundamental issue in understanding what the courts were for. people came to you for a certain reason. Whether they was rightly came to you or not, that's a different thing. You do it outside the court system, create the culture. Not a problem. We need to create the culture, but that has to happen outside the court system. People have to understand how mediation works, and it works. But the user experience will only come in if the right people are doing it. The right people will not do it because they can't take it up as a profession. Why would a person keep doing this if he's not going to be paid for it? And the court system is going to finish that off, because I'm saying, even if they charge $1, they're wrong to charge $1 for mediation, because you have forced a party to take a process which the party did not want to take. They said, I wanted to do litigation. I've come to you. You decide my case. No, we can't decide the case because we don't have the infrastructure. We don't have the enough number of judges. So you go for mediation. Then you can't charge them. Why would you charge for an additional process which you are making mandating on them? So you can't. You should charge. They should pay zero, and the parties pay zero. What is the message we're sending? Mediation is connected to courts, and mediation is free, and that is the profession ends. And the long-term vision doesn't seem to be there, that the backlog will obviously will be there if you don't have an input-output ratio of a matter, that less come in and more go out in terms of matters. In India, it's the same. As many that come in as they go out. Those are every year. So 43 million cases are going to be in the court system for life if the system doesn't change. Civil Procedure Code, I mean, I can talk for India. I know that we have a 1908 Civil Procedure Code. Imagine 2021, we have a 1908 procedure code that is not changed, but we want to tamper with the mediation aspect of it. We want to regulate mediation because we think that people cannot be mediators. They will in some way mislead parties, it seems. They are not capable. Up till in the court system in India, Civil Procedure Code says you have to have 10 years of experience if you can be a mediator in the court system. But a lawyer who graduates day one, enrolls in the bar, can defend a person who's on the death penalty. Lawyer can do it, and that is something that is decided by the court, and you are an officer of the court. You're supposed to brief the court. You can do that, but parties who have to take the decision on their own, oh no, you might just blow it up. I don't know what you're going to do. Is this some rocket science happening there, and you will be able, you'd spoil the entire concept. I think there is some fundamental issue in understanding, or I'm saying the other vested interests there. They just do not want. Say the mediation centers that are run in the country, they're senior lawyers who are running them. Those senior lawyers are charging thousands of dollars for each hearing. And on the same mediation center, a mediator is paid $10, $50, $100 for the entire mediation. So I think we have to go into the fundamental issues, root of the problem. If mediation has to develop, it's the best thing we say as mediator. We are sitting there, we know it works. We know that parties come out the way they come out. I mean, if all that is happening and it's possible, why has it not taken off the way in countries where 45 years, like I told you, in the way it should happen? The way it's practiced. I mean, Michael Lang was there from the US. He's a lawyer, and now he swears by mediation. But he has this problem with the concept the law court system has created transactional mediation. Everything is a deal. His concept is mediation is much more than that. There is more that you bring in as a mediator. So I think we have to be able to get into an understanding a lot of things beyond that. I think we are not, those discussions are not happening because the people who should have the discussions sit together in this Zoom meeting and keep discussing it, and the user is not part of it. That's why we were yesterday. I think Andrew was also saying this, that all these discussions happen here, but right next to it in the world, in that LinkedIn, all the mediators are sending out posts and looking at it, but that user is not even touched by that. So I think that's communications. We have to start that now. After this symposium was to bring out the culture aspect of it, that is part of culture. Let's bring that to the world, to the people, that this is part of it. And interesting things like David has come out with this hybrid thing. Let's take that to them and let's get this going. And let's now talk to the people. So next, all my focus is going to be getting people into it and how that has to happen. And all of you have to give me suggestions also and work with me on that. Now it is activating people and getting it there, and let's get work for mediators. And once they have work, they have such a large role. Ken Cloke talks about the role of mediators in social problem solving. He has created this very large role. He wants the role of mediators in everything that happens, right in the global level. He's talking about even in the climate change discussions, you must get mediators in because they will facilitate dialogues. A lot of dialogue has to happen. Same thing at the national level. There are social problems. Interestingly, one of my that show that I do in Conversation with the Beautiful Mind, Louis Ore from Peru was there. How in Peru he's part of the Prime Minister's office. They have a group of mediators they've appointed. So how at the community level they are going there and doing mediation. They have a stadium. Imagine a stadium full of people, and it is those people physically there. This mediator is physically there. Government officials are there online. So here a dialogue with the community and the policy makers and the decision makers is happening right there. So the whole concept of using technology to our advantage and connecting people and creating that dialogue, I think there are a lot of things happening in this world, and I think with me having these conversations, I'm picking up a lot of interesting things. So that's how I look at it. So Girija, any other final words? It's not final words up till Sarah doesn't come in. We have time. So she sorts
Well,
it.
I said most of what I had to say, and I do agree with you that we need to carve out better roles for mediators and better places for mediators to do co-mediation opportunities and mediation opportunities. I think that's going to, you know, a concerted effort, a joint effort will definitely make a difference.
But I think that's the starting point for me now is going to be identifying these people who are I'm going backwards. I'm going talking to kids in schools. I'm saying that are there children whom you trust? And it's not that I have to do it. I don't have to create a organization or anything. I'm totally against that concept. I mean, individually, if I can do a symposium with 80, now it's going to be 80 plus speakers from about 40 countries. So individuals can do a lot. So let's get individuals who want to do all that, get them together and have these conversations and tell them that look, you identify these people, you work with them, you use them, and you have to at that school level itself, that whole mindset. I was talking to, there was a conversation with this person from Nigeria, so his son was there. I said, let's call your son and let's have a conversation with him. I asked him, look, in your school, is there someone who helps you resolve your dispute? He could not really say anything about it. I said, what about you? What do you think? He says, I will never do it because I'm scared of the teacher. Can you imagine? You are scared of a teacher and you will not help your friends resolve their dispute. This is where the concept of authority has been pushed in. And I am saying that whole colonial concept and the mindset and everything that has happened because of that, we have to untie all those things in the mind. Virash yesterday was also talking about the psyche of the people. Of course, for her, the racism and the apartheid and all that aspect was obviously those have created a lot of issues in the mind in South Africa. But I'm just saying the psyche of the people, which has been affected by all these things that have happened. Colonization is a major factor. I mean, you've changed the whole concept of dispute resolution. Even today, if I say that the Chief Justice of India sets up a committee to look at a mediation law, why are you touching mediation law? What do you have with the mediation law? Touch your civil procedure code, which governs the procedure in your court. Nothing happening on that. That's 1908. We have the best law in the world on, we call it conciliation because I keep repeating this because UNCITRAL was calling it conciliation. They have clarified today in the 2018 model law that time we were using conciliation, but because mediation word is what is used, we are shifting it to mediation. It's the same thing. Substantively, there is no difference between the two. The definition they put out, such a broad definition, whatever name it is called, however the process is conducted, the person should not have authority to impose a decision. So they've put that out. It's such a broad thing. Everything fits into it. And you call it what you want. Why mediation? Why conciliation? In India, I mean, of course, David talks about Sula. In our country, we have a law which is called conciliation in English. It is called Sula in Hindi. It is called Sula. So if someone says there's a law on Sula, we have a law on Sula. So everything is available to us. We have the best law in the world. And today we have to just take it down to people. They get a court decree sitting in the village. Does that shake up the judiciary? Why do you want to tamper with it? Does it shake you up that people are empowered today? They can actually get a court decree and no one has told them about this. Sitting in a village, imagine a high court from a village might be 1,000 kilometers or more, maybe. The person will take so much time to get there and nothing will happen. He'll go back with nothing except paying the lawyer. He can sit, or she, whatever gender again, can sit in their village and get a court decree. Can it get better than that? No, we must tamper with it. We are going to lose control. We are the judiciary, we are the colonial legacy that we have to continue. The robes in our court, your lordship. They want to be called your lordship. I mean, a court should say, please, you are not going to call us your lordship. No, we want to sit on a pedestal. We want to be called lordship. The system that we have created, the entire colonial atmosphere there, just don't want to let go. Please let go. That is the only most inefficient institution in this country, at least. Well, let's talk about let others talk about it. I keep saying that if villagers go to the government and say that make a road to connect our village, and the government tells them no, you make the road yourself, and forces them to make the road themselves, the judiciary will step in. How can you do that? But if the judiciary does it, they are trying to promote mediation. Very nice. What are you trying to promote? You're promoting something where the parties could do themselves. They didn't want to do it themselves. That is a issue that we'll take up with the parties, and how we can promote mediation outside the court system. So it's a lot of factors which are working together, and we have to be able to understand that, and as fast as we can understand that, because I'm telling you that this tampering with the law, that whole committee and are they vested interests? I won't say they're vested interests. Are they vested interests? We have to question that. Is it working because of self-interest? We have to ask ourselves that. Because why would a perfect law, which has everything going in it, you said that the definition of mediator, conciliator, it's total flexibility. The fact is, he may suggest, because of the fact that tomorrow the party should not say that the mediator suggested or conciliator suggested. Sarah's here now. So, Girija, now your final words.
All right. So, thank you very much, Vikram, for this very interesting discussion. And my regards to Mr. David Shimoni and Mr. Giovanni Matucci. Thank you very much.
You can say hi to
And
Sarah.
hi, Sarah. Good to see you, but it's time for me to leave. And I'll take leave then. Thank you very much, Vikram.
Yes, just give me once. Yeah. Perfect. Thanks a lot, Girija. Thanks for always nice
Bye.
talking to you. And don't be so busy. Take time off always to talk.